But listen, Ms. Pew, don't speak over me. Ms. Pew, just because you say respectfully does not mean that you get to interrupt me. That's disrespectful, right? Hang on. Listen, Ms. Pew, stop talking over me. If you want to stop talking over me.
Where is the verified claim that is being placed against my trust?
You can go back with the bailiff. Go back with the bailiff. Get your own attorney or represent yourself if you don't like it. Good morning. Are you Janetta Pew?
I am the beneficiary of that estate.
You're the what?
I am the beneficiary of that estate.
You're the beneficiary of what estate? Answer my questions, please, ma'am. I'm just trying to understand. Okay.
For the record, I recognize Ms. Pew. She's been here before.
I do as well, for the record.
And I looked into Mr. Christopher Wiley. I can't find that person as a practicing lawyer in the state bar page, and I have not been contacted by anybody on Ms. Pew's behalf.
All right, so Ms. Pew, Mr. Lewis has been appointed to represent you at this point. Obviously, you know as well as anyone that you're in custody and we want to get your case taken care of. If you've hired or your family has hired another lawyer, then they have to contact the court so that we can do something with your case. And do you know if they've hired someone?
Respectfully, Your Honor, I do not agree with your appointed foreign agents, considering that the first duty is to the state and will be considered conflict of interest.
Okay, so if you don't want, the only thing I can do, I'm appointing an attorney to you to help you, right? So if you don't want a court-appointed attorney, then your only option, two things. One is to represent yourself or to hire a lawyer. So if you don't like the way it works, then you do something different. So are you, listen to what I'm saying. Are you either going to represent yourself, or are you going to let Mr. Lewis represent you, or are you going to hire someone?
Objection, Your Honor. Respectfully, is this a court of record?
It is a court of record. So your objection's overruled.
Okay. Respectfully, Your Honor, where is the verified claim that is being placed against my trust?
It's right here. It's called an indictment. And Mr. Lewis has a copy of it, and he can show it to you. So that would be the verified claim against you.
Okay. Your Honor, respectfully, Your Honor, there were writs that was filed to the case that still haven't been received.
I've received your petition for writ of habeas corpus, and it's denied.
Okay. Respectfully, Your Honor, I demand to be released due to lack of evidence of stated claim and not being given the proper opportunity to obtain proper counsel defective defense.
It's overruled.
Okay.
You're running out, aren't you?
No, it's fine.
So here's the thing, Ms. Pew. I appreciate your position, but listen, Ms. Pew, don't speak over me. Ms. Pew, just because you say respectfully does not mean that you get to interrupt me. That's disrespectful, right?
The defendant, Janetta Pew, is employing a textbook sovereign citizen strategy, a desperate attempt to transplant civil trust law into a high-stakes criminal proceeding. By questioning the verified claim against her trust and referring to herself as a beneficiary, she is attempting to delegitimize the court's jurisdiction. However, the law is not a game of magic words. In Texas, as in all U.S. jurisdictions, a criminal indictment serves as the legal notice of charges, and the court's authority over the person is established the moment they are arrested within that jurisdiction. Pew's insistence on foreign agents and conflict of interest regarding her attorney isn't just a misunderstanding of the Sixth Amendment, it's a deliberate obstruction of the process. The judge's frustration isn't personal, it's a procedural necessity. When a defendant refuses to acknowledge the basic reality of the charges, the court must intervene to protect the integrity of the record.
Hey, hang on. Listen to me. Everything you have there is overruled. And here's one of the reasons why. Is because you have a lawyer. And your lawyer will file the appropriate motion. You're interrupting me again, which is disrespectful. So I'm going to leave Mr. Lewis as your attorney unless you choose to represent yourself or hire someone else. I'm going to give you 2 weeks to determine what you're going to do. You can go back. You can go back with the bailiff.
I do not agree or comply to your appointed
Go back.
agents.
You already said that, and that's overruled.
Duty is to the state.
Go back with the bailiff. Get your own attorney or represent yourself if you don't like it. Perfect. So Ms. Pew, Mr. Jeffries has been appointed to represent you. He's just been given, he's trying to get caught up real quickly on all the information and the discovery in your case. I'm going to reset your case so that he can get all of that. Once he gets it, he'll be out there to go over it with you, and we'll see if we can get an announcement at the next court date. All right.
Respectfully, Your Honor, I do not agree to comply with any of your appointed court agents, considering that their first duty is to the state.
I understand. We've had this conversation before.
And for your record, I'll be representing myself.
So if you want to represent yourself, there's some things. Ms. Pew, stop talking over me. If you want to stop talking over me. If you want to represent yourself, then there is a process that we have to go through, and we'll do that today if that's what you want to do. We'll get your case set for trial and we'll go forward that way. It is highly inadvisable for you to represent yourself. Lawyers have many, many years of training. They understand the law. They understand how a trial works, because here's what happens. When you're in a trial and you represent yourself, you're expected to know and follow all of the rules of evidence, all the rules of procedure. And so you're really at a disadvantage if you don't know those things. And so you have to do everything just like the assistant district attorney would. And if you don't, you're going to be in front of a jury and it's going to show, and it's just not going to be, it usually does not work out in your benefit. But I have to go through with you some questions first before we do that. And then if you still want to do that, then there's a couple of things couple of options, and we'll go over those as well. Okay. So I am supposed to ask you, I'm going to go through these questions. I need you to answer them if you want to represent yourself, because this is required. All right. So have you ever studied the law? Okay. Have you ever represented yourself before in any kind of criminal matter? Okay. Do you understand the charges against you? Okay. And so do you know, and we've gone over before, I think, what the range of punishment is if you're found guilty on a jury? Do you know what that is? Let's see. Hold on a second. Let me pull you up here. We'll go over that again as well. The date of that allegations from June 22nd of 2021. And what that means is if you're found guilty, that the range of punishment that the jury could give you is between 2 years as a minimum punishment up to 10 years in prison, anywhere in between. Do you understand? And you answer out loud just for the record.
Do I understand? No, I don't understand.
What do you not understand about that?
I don't understand, Your Honor.
So here's the thing. If you want to represent yourself by law, you have to be able to understand these things. Otherwise, I've got to appoint an attorney for you. So you can't just say, I want to represent myself because I don't like the attorney or I don't like the process. This is the process that you're in. You live in Texas, you live in the United States. This is the law that applies to your case. So what do you not understand about the range of punishment if you're found guilty? And I'd be glad to explain it.
I don't understand because I haven't been anything wrong.
That's what a jury's for, right? And so if you say you're not guilty, then you go in front of a jury and they determine after they listen to the evidence if you're guilty or not. That doesn't have anything to do with if they find you guilty, you understanding that they could send you to prison for between 2 years and up to 10 years. Do you understand that part? What are you, yes or no? No, you don't understand that. So, Ms. Pew, it's my understanding, I'm not going to allow you to represent yourself because you don't understand the law and the process. So we're on question number 4 out of 15 that I'm supposed to ask you. So Mr. Jeffries is going to stay on your case. I don't care what you want at this point. You can't do it. All right, you can go back with the bailiff. I'm done. Go back with the bailiff.
It's not on my case.
Go back with the bailiff.
It's not on my case.
Welcome to the criminal appointment list. This was not meant to be any kind of punishment, I promise. So Mr. Jeffries, just, get ready like you would. Probably it's going to go straight onto a jury. And we'll just get it figured out that way. All right.
Under the landmark Supreme Court case Faretta versus California, a defendant has a constitutional right to represent themselves, but that right is not absolute. As this judge correctly demonstrated, a defendant's waiver of counsel must be knowing, voluntary, and intelligent. The moment Ms. Pew claimed she didn't understand the range of punishment, specifically the 2 to 10-year prison sentence, she effectively stripped herself of the right to represent herself. You cannot, knowingly, waive a lawyer if you cannot grasp the basic consequences of the trial. The judge was cornered. If he allowed her to proceed while she claimed ignorance of the sentencing, he would be served an automatic reversal on appeal for a defective waiver. By forcing her to keep her attorney, the judge is actually protecting her constitutional rights, even if she's screaming that he's violating them. Let's talk about the sovereign citizen tactics used here. These defendants often believe the court is a maritime entity or a corporate boardroom. They view the judge as a fiduciary and the indictment as a bill. This is legal fiction. In the real world, the world where handcuffs are made of steel and prison cells have bars, the indictment is the only verification the state needs to hold you over for trial. Pew's demand for a verified claim is an attempt to apply the Uniform Commercial Code, UCC, to a felony criminal case. It's like trying to play baseball using the rules of Monopoly. It doesn't matter how loud you yell about passing and go, you're still going to be called out at first base. Respect the bench. You can disagree with a judge, and your lawyer can preserve those disagreements for an appeal, but interrupting the court is the fastest way to lose your leverage. This judge gave her multiple lifelines. Resetting the case to let a new attorney get caught up was an act of judicial patience. Pew threw that back in his face by continuing the script. In the end, this wasn't a trial about guilt or innocence, it was a competency test that the defendant failed. She will now go to trial with a professional advocate she doesn't want, to face a jury she doesn't understand, for a crime she refuses to acknowledge. It is a slow-motion train wreck that could have been avoided with 5 minutes of actual legal advice instead of internet pseudo-law. What do you think? Was the judge too harsh in stripping her of her right to represent herself, or did he save her from her own delusion? Sound off in the comments.